What are we doing?
Your Honor, Mr. Barnhard is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Is the court in receipt of the bond violation report from Community Corrections?
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond.
All right, let's break this down. The prosecution just revealed Barnhard tested positive for multiple substances. Immediately after being released, cocaine, THC, benzodiazepines, and even Suboxone. That's quite the cocktail. His defense, however, argues this may not technically violate his bond, claiming he could have used before being released. But here's the kicker. The prosecutor checked the jail records, confirming his release just days earlier. In court, this kind of argument is called temporal defense, shifting focus to timing to create doubt about a violation. The problem? Judges often see through that when the pattern of use is this consistent. What do you think should timing really matter if the risk to the public remains the same?
Time that these substances were consumed, therefore it may not be a bond violation. However, I did double check X jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument. But
can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those,
what?
I mean, cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, well, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, since I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
This moment right here, when the judge says luck's going to run out. He's going to take somebody out that's not just legal reasoning. That's a chilling reminder of what these hearings are really about. Prevention. The court's job isn't only to punish, but to protect. And even though the defense insists Barnhard isn't driving, the judge's frustration is clear. Past behavior predicts future danger. When someone's tested positive this often, the fear isn't hypothetical. It's statistical. Judges deal with this daily, the moral tightrope between compassion and consequence. Tell us in the comments, do you think the judge should revoke his bond entirely, or does he deserve one more chance?
But here's, again, my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones, and he's still using. So I don't know that he should be out, because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out.
I don't have a vehicle.
Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point, because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5 with another one pending in Wayne County, and he's still using. You're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that. No question. I think him failing those tests, and we don't have a pattern or anything like that. You know, we don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I get that search to the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
At this point, the prosecution brings out the receipts. 3 prior OWS plus new 2023 and 2024 cases, and even a blood alcohol content over 0.30 in 2 of them. For context, 0.30 is almost 4 times the legal limit. That's blackout territory. The defense's claim that there's no pattern just fell apart in real time. What we're watching is a classic escalation argument, the judge weighing rehabilitation versus public safety, and the prosecutor hammering home a pattern of risk. When you have a defendant who's repeatedly violated trust and the law, the court has limited options left. The turning point is coming, and it's not going to favor the defense.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond was an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set, because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving a car. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash as surety. So you're waiving your right to preliminary examination in these cases? Yes, sir. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution? Sir. People also waive their right.
We waived, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
Sign the
It
form
might
to
have been
waive after
PRs,
this.
$25,000 PRs, but I
There, I have on each of these that they're PR.
Oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive.
We do.
Preliminary examination haven't been waived. Defendants bound over to circuit court on a single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with Judge Conlin.
September 24th, 2025, 1:30 before Judge Conlin in each of these matters. The bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded. Yes, you may.
And there it is. The judge officially revokes the personal recognizance bond and replaces it with a $25,000 cash assurance. That's a major escalation, signaling the court's final warning. Freedom now comes with a price. From a legal standpoint, this case is a textbook example of risk-based bond modification, where the defendant's history, substance use, and public safety concerns override any benefit of the doubt. Emotionally, it's a sobering end to a pattern that's been building for years, whether you see it as justice served or another tragedy in the cycle of addiction. One thing's for sure, this courtroom didn't hold back. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns every week here on Justice Desk.